Good afternoon, everybody. Hey, I was sitting here thinking about a challenge, how we can roll up our sleeves and make this happen. Remember last year I was talking about the different ways that the 501c3 status could be revoked. And I brought to the community for the ex Scientologists and the survivors to do an FBI claim against the FBI into the Department of Justice. And it really got me thinking about where we could go with this because, to be real honest, quite a few people put in complaints to the Department of Justice OIG, the Office of Inspector General, against the FBI. There was quite a few of them, and it just absolutely went into a black hole. Then the Never-Ends put in their complaints, just went into a black hole. And I kept thinking to myself, what in the world? Why isn't this getting looked at? There's such a huge issue with the abuse and the abuse of the 501c3 that there has to be something more to it. So I'm going to refresh your memory. I'm going to look at this. So there are 5 ways that the IRS, the 501c3, can be taken away. Per the IRS document, publication 1828, page 4 lists the IRC, the Internal Revenue Code, rule for exempt organizations, 5 distinct ways to lose your tax-exempt status. Jeopardize the tax-exempt status. Their net earnings may not inure to any private shareholder or individual. Back in 1967, that's how they were originally taken away. They must not provide a substantial benefit to private interests. They must not devote a substantial part of their activities to attempting to influence legislation. And keywords here are substantial, you guys. There's no definitive answer to substantial. They must not participate in or intervene in any political campaign on behalf of or in opposition to any candidate for public office. And those 4 ways are adjudicated by the IRS. The IRS determines what substantial is. They determine whether somebody was or an organization is participating in or intervening in political campaigns. That's all adjudicated by the IRS. The 5th way is adjudicated by the Department of Justice. The organization's purposes and activities may not be illegal or violate fundamental public policy. Keyword there, keyword phrase is organization's purposes, not an individual. So, for instance, Warren Jeffs, he went to jail. The 501c3 was not pulled for the FLDS because it wasn't the organization's purposes and activities. It was Warren Jeffs' purposes and activities. Same with the Catholic Church. Catholic Church didn't lose its 501c3 status. The priests went to jail, or the priests were admonished for it. So that's the difference. It has to be the organization's purposes and activities. So all of these, the first 4 were all limited by the 1993 agreement, which is false in its premises. I've attached the full closing agreement between the IRS and the Church of Scientology, but we're going to look through this Church of Scientology. Hold on, let me get to that. Okay, so here's the full text. It's an 86-page document. We're not going to go through the whole thing. Excuse me, I'm going to read some key points of it, though. In fact, I'm just kind of skim through. There's a couple of, whereas the church and the service intend this closing argument to be final and conclusive with respect to all matters but while also final and conclusive, that its provisions relating to the continuing duties and obligations of both parties during the transition period shall generally be effected until December 31st, 1999. So 2000, the year 2000, January 1st, 2000, this document became, the provisions of this document became obsolete. So it doesn't mean much. They're still running on their 501c3. As I said, I will link a copy of this. There was one more spot. First, under Section 2 of the agreement, the church will make a single payment that is intended to extinguish any potential tax liability that may be due and unpaid by a Scientology-related entity for all tax years up to, so they got a chance to pay off any outstanding tax debts. Second, under the Section 2 of the agreement, the church and the service will withdraw from virtually all existing controversy. So let's wipe the slate clean. No problems. Don't look anywhere. Third, it's the view of the service that certain church entities are entitled to recognition of the tax-exempt status as entities described in Section 501c3 of the IRC. Thus, Section 3 of the agreement contains a list of entities that will be recognized as tax-exempt entities, including certain entities that will receive group exemption letters covering their, so all the RTC, the CIS, the COS, all of the ABLE, all of them, Narconon. So anybody related to the Church of Scientology or Scientology International receive the 501c3 via them. Notwithstanding the above, in light of inter alia, the size and complexity of the church and the service, certain concerns of the service and church remain. Again, just kind of running through some of these things. I'm going to go through the timeline. Church of Spiritual Technology, Church of Scientology International, all the trust funds, RTC. Here are the following individuals: David Miscavige, Norman Starkey, Mark Yeager, Mark Ingber, Lyman Spurlock, Patrick Broker, Anne-Marie Tidman Boker. All of them were exonerated from all of their past levies and tax liens. Amazing how that works. All of them got all of their names cleared in this agreement. Again, as I said, we're going to go through flag organizations. So Inspector General Network, International Hubbard Ecclesiastical League of Pastors, I help. Building Management Services, we see them a lot. Bridge Publications, Dianetics Centers International, Dianetics Foundation International, Hubbard's Dianetics Foundations, the U.S. IAS Members Trust. The IAS Members Trust is where all the money is being held. That's the mother lode. The service agrees that the organizations listed, blah, 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 that need not file annual forms 990. Imagine that. So in also Church of Scientology International, Scientology Missions International, Applied Scholastics, CCHR, Hubbard College of Administration, which isn't really, Those were all brought in. Basically, any company, any additional 501c3 made after this agreement was also brought in. So it wasn't just those that were in existence before. It was anything that they made afterwards too. Wouldn't that be just cool to be able to have? Okay, so CSI, RTC, CST, Flagship, FlagServe, FSO, Western, Religious Education College, Celebrity Center, the Missions International, Hubbard's Ecclesiastical Legal Pastors, the Scientology Religious Trust, International Reserve Trust, Flagship Trust, New Era, Bridge, BMS, FSO Oklahoma, World Institute of Scientology Enterprises, the Africa Church of Scientology Advanced Organization, St. Hill, Europe and Africa, SOR, which is the UK, Cyprus, Transcorp Services, San Donato Properties. Just amazing at how many that are listed in this. So every year they're supposed to be doing a fiduciary reporting. Here's the requirements. Compensation information. For each calendar year and issue, the annual report shall contain the following information with respect to compensation paid certain individuals by Scientology-related entities. The names and total compensation paid to each of the 20 natural persons with the highest amount of compensation during the calendar year for an issue. For the calendar year in issue. The purpose of determining the highest paid individuals, the compensation of an individual includes amounts received from Scientology-related entities by the spouse of that individual, where a spouse has such compensation. The spouse's name and the nature and the amount of compensation are to be separately listed. To determine those individuals for whom the paragraph requires disclosure, all compensation from all Scientology-related entities is to be aggregated. A husband and wife are to be treated as a single entry on this list, not as two highly paid individuals. I thought that was very interesting. There was a couple other things on here, not too many that I highlighted. Okay, so no Scientology-related entity or Scientology-related individual in his or her capacity as such has, after 1986, knowingly committed any act of fraud, here's the pinky promise, you guys, or criminal conduct that might constitute a violation of public policy, endangering the tax-exempt status of any Scientology-related entity, assuming for the limited purpose of this paragraph that all Scientology-related entities are otherwise described in code blah, blah, blah. That all qualified written materials submitted in connection with this agreement was correct and truthful as the date submitted through the date of this agreement as supplemented and filed in August and September 1993. There's your pinky promise, guys. Did that happen? Did any of them, we're talking about Narconon, Abel, Wise, we're going to come up to a Wise thing here, any of them knowingly commit any act of fraud or criminal conduct? No, not at all. So here's another one that I thought that was very interesting. The members of the CTCC, which was this committee that that made this agreement, no later than 1995, effectuate the dissolution of WISE, Inc., and transfer all of its assets, including but not limited to its rights to Scientology religious marks, to the Inspector General Network. Did that happen? Did that happen? Again, I'll link this. You can read in all of its full glory. I think that probably was until we get to, there's the penalties, blah, blah, blah. Basically, it's just, I know I've been saying blah, blah, blah a lot. For the penalties imposed by reason of special non-charitable expenditure defined in paragraph, the amount involved is equal to the greater of the difference between the assets of the corporate members before the impairment of the guarantee, or the lump sum of $25,000, that's just bull crap. Okay, so here are all the reporting. Nothing strange or unusual in there. Flagrant misconduct means for any act of self-dealing, for any non-charitable expenditure. So these are all things that could get them in trouble. The phrase repeated with respect to misconduct means more than two occurrences of conduct, resulting in the imposition of second-tier sanctions. Nobody ever really looks at any of that. And again, this kind of dissolved in 1999 anyways. But there were parts that were. Okay. So here are two that I want you to look at. Remember, and we're going to discuss this in just a minute, all those thousands of lawsuits that everybody keeps saying that's the reason they got their 501c3 status back. No can do. Not so, Brother Bear. It's specifically these two lawsuits, Powell and Neves. These two lawsuits are the two specifically that they received their 501c3 back. And I'm going to explain to you how. It wasn't the thousands. That was just a ruse. Here's another one. The service also agrees to withdraw, obsolete, or supersede Revenue Ruling 78-189 no later than April 1st, 1994, irrespective of whether the audit policies or practices described in paragraph B are ever issued. We're going to discuss what all of these things mean. You get down to the bottom of this, and I think there was one other church signatories means the following entities: RTC, CST, Church of Scientology Religious Trust, BMS, Church of Scientology Flag, FSO, and Western United States. And where do we get to the signatories? We're almost there. Okay, so the date of the agreement was October 1st, 1993. Signed by David Miscavige, Norman Starkey, Mark Rathman, Heber Jensch, Mark Yeager, Jonathan Epstein, Nigel Oakes, Mark Rathman, Heber Jensch, CST ended up being POA signature, flag POA, Western United States POA. So somebody signed for the chiefs of those. So Commissioner of Internal Revenue Service, John Burke and James McGovern. Those were the signatories. So Marty Rathman had a big deal with this. And I believe that Claire was the head of RTC at the time. Even though her signature's on here, they POA'd her signature. So amazing that. Okay, I'm going to pause while I get into the next section. Okay, we are back. Now I pulled up a Word document that's kind of going to guide us. I probably will not link this Word document, but we will talk about different aspects of it. So, looking at the first four, the adjudicated by the IRS, and then the fifth one, the organization's purposes and activities, going through that, and let's use that, those things that I was talking about in the 1993 agreement. How did that 1993 agreement come about? Here, I'm going to tell you a little. Let's dig into it. What happened? 1967, Scientology loses its tax-exempt status. And that was because it was their net earnings may not inure to any private shareholder or any individual. And that was because L. Ron Hubbard was being inured. He was using all of the money. He was gaining all of the money. So they snagged his 501c3 status. And they became just a church. Now, remember that a religion, a church, is tax exempt by nature. They do not file a tax return. They do not file taxes. When you give money to a church, when you donate money to a church, it is, you can take it off your taxes. It could be part of your refund. That does not mean not all churches are 501c3 status. 501c3 status allows more benefits above and beyond just tax exemption. It provides being able to get and give grants. It provides having property tax exceptions. There's other benefits to being a 501c3 that you gain, but you don't get them just because you're a church. You have to apply for the 501c3 status, which is those other areas where I told you the 4 ways, and then the 5th way is for illegal activities that you can lose the 501c3 status. So in 1967, they lost their 501c3 status. But from 1967 to 1993, there were some lawsuits that were because people wanted more than just donations. 1984, this one happened to be a lawsuit that came about. It's called Church of Scientology California versus the commissioners. They are IRS commissioners. And this basically was referring to what income that the Church of Scientology California, which was not part of the Church of Scientology church itself, they had to report their income. And at that time, they were reporting income of Hawaii and the UK, because the UK lost its tax exemption. And they were fighting the fact that they had to also report UK's money. That's what the whole lawsuit was over. Well, the judges opined that about the 501c3 status in general. And On March 5th, 1980, the court ruled that compliance, I'm going to read this because this is kind of interesting, that the compliance with public policy is a requirement for exemption from the tax under the 501c3. In a memorandum sur order dated April 1st, 1980, this court denied the scope of the public policy requirement by stating, this requirement is limited to compliance with well-defined public policy, such as may be rejected in a criminal or civil statute. The respondent's trial memorandum, lit on October 3rd, 1980, cataloged a series of petitioner's acts, policies, and procedures which respondent intended to prove to show the petitioner's failure to comply with public policy. These acts, policies, and procedures included, let me read these: conspiracy to impede and obstruct the Internal Revenue Service. 2, abuse of the role of religious confidant by auditors. 3, the infliction of psychic harm, including the loss of moral judgment through brainwashing, accomplished by auditing and other practices and procedures. 4, the use of blackmail and intimidation to implement petitioner's fair game policy. This is all on record, guys. 5, the involuntary dissolution of marriages and family ties through the enforcement of petitioner's disconnect policy. 6, involuntary detention and false imprisonment. 7, the making of false statements to immigration authorities. 8, the removal of large amounts of currency from the United States without disclosure. 9, the false registration of petitioner's fleet as private yachts. And 10, the drastic punishment of staff and members. Respondent also contended in this letter, now this is the commissioners, in a letter to petitioner in connection with the petitioner's motion to render the notice of deficiency, negatory, and for other relief, that 1, the church's methods are akin to brainwashing. This is hilarious. 2, the church employs tactics which are harmful to society. 3, the petitioner is a cult. Okay, they're even saying they're a cult. And 4, the Scientology operations are partially a profit-making scheme, MLM, and church policies and practices endanger the moral and physical health of citizens and create trouble in families. What the hell? You guys, this is all on record, straight from the IRS. How does it get any more plain and simple than that? So that happened in 1980 going to 1984. This was published. This is published in the court case. So then in 1984, Graham versus Commissioners, this is a tax one. The tax court in Graham found that because the taxpayers' payments in the Church of Scientology were made with the expectation of receiving a commensurate return benefit, namely auditing and training services, and because such a benefit was actually received, the payments were not charitable contributions, but rather quid pro quo. So 1987, the appeal goes on. Nope. It's turned down again. 1989, this goes to the Supreme Court. The Supreme Court, the law of the land, the top dog in all the courts, said payments made for courses and audits and ethics are with an expectation of quid pro quo and therefore not tax deductible. However, noting that, Sandra Day O'Connor writes a dissenting view that Scientology is being discriminated against and the decision should apply all or none other religions. The IRS is not being consistent in its actions. So, with that being said, what happened is the law of the land said, they said, in the Supreme Court that you cannot write off audits, ethics, in courses, in your books, and all of that. Those are not contributions. They are not tax deductible. That's it. That was all. In 1991, Powell versus United States, that case came out of Florida, and it basically said that the IRS was discriminating. They were using Sandra Day O'Connor's opinion and her dissenting view that it wasn't being consistent. Now, see, the consistency was that the Jewish tax, the temple tax, and the Mormon LDS were using their contributions and payments to schooling and the temple tax, and they were getting to write them off. So the problem is that if they hold this to the Church of Scientology, they being the IRS, if they say, nope, you can't do it, then they're going to have to go back to the Mormons and the Jewish temples and say, you can't write it off either. And God forbid that happen, because that would cause a huge uproar, a huge voter base chaos. And there was no way that the IRS wanted that to happen at all. So there were two cases, Powell versus United States, remember? And then the Garrison case. And that was the second case. And to be real honest, it looked like they were going to win both of those cases. And what would happen is then the Supreme Court would have to go back and either rehear, open up those appeals for the Hernandez case, or take away the tax deductions of the rest of the religious communities. And that seriously just was not going to happen. So in October 1991, David Miscavige and Marty Rathbun walked in to the commissioner's building and said, we want to meet with the commissioner, which, hey, that never happens, but it did, right? So David asked the commissioner to reinstate the 501c3 status, and in return would drop all the lawsuits, including these two cases, Powell and Garrison, because they knew that was going to happen. All hell would break loose if those two cases were won. So the Commissioner Goldberg convened a special committee of 5 IRS agents and Scientology lawyers to negotiate a settlement. Scientology outside normal agency procedures. When the committee determined that all the Scientology entities should be exempt from taxes, IRS tax analysis were ordered to ignore the substantive issues in reviewing the decision according to the IRS memorandums and court files. Basically, all the findings in the 1984 case, the Church of Scientology, California versus Commissioners, Howard Schoenfeld, who was the official that was picked as the committee chair, said later in a deposition in the tax analysis case that he recalled only one other similar committee in 30 years at the agency. So in February 92, Commissioner Goldberg retires. It's not my problem anymore, right? Leaving an acting commissioner and 3 following commissioners to deal with the fallout of the negotiation. And basically, new commissioners, first of all, the acting commissioners aren't going to do diddly squat. And the brand new commissioner that came in that finally did take the spot, they're like, this is old business. We don't want to have to deal with this. Probably just go along status quo, right? And basically that's what happened, is it got pushed through. 1993 October, surprisingly, the saga was about to take an unexpected turn. Mr. Schoenfeld, remember he is the chair of the committee, the negotiations chairman, ordered the two tax analysts assigned to the review not to consider any substantive matters, according to the memorandums. So it's not Mona saying this. This came right out of the memorandums and the records in the tax analysis case. Those issues, Mr. Schoenfeld informed them, had been resolved. Remember, they pinky promised they're never, ever going to do anything bad again. So both of the analysts, Donna Moore and Terrell Burkowski, wrote memorandums specifying that they had been instructed not to address issues like whether the church was engaged in too much commercial activity or whether its activities provided undue private benefit to its leaders. Mr. Schoenfeld, who has left the IRS, said he could not discuss the case. However, the senior IRS official involved in the talks said there had been nothing sinister about the instructions because those matters had been decided by the negotiating committee. Imagine that. He acknowledged, however, this was not the typical procedure. So not only did the IRS not attempt to extend the Hernandez decision to other religions, it confused the matters by, in effect, overturning the Supreme Court Hernandez decision in 1993 with a revenue ruling 9373. The revenue ruling allowed the deduction of the very payments the Supreme Court had refused. The Supreme Court said no. The IRS went behind their backs and said, yeah, you can. Some questioned the lack of candor exhibited by the IRS in the settlement. The IRS was not forthcoming as to its reason for the settlement and for turning its back on its victory in Hernandez. Numerous authorities wrote to question whether the IRS could legally ignore and, in effect, overturn a Supreme Court decision. They couldn't. They can't. They did. They completely ignored the supreme ruler of the land. It does appear, however, that ruling 9373 is subject to challenge on the same basis that Scientologists argued administrative inconsistency in Powell. Furthermore, it appears that the revenue 9373 opens the way to challenges by all types of taxpayers. So what's funny is that if you go look now, 9373 isn't even in the books. They completely pitched it. They hid it. It's no longer there. But it's in the records. It's in the records. These are their documents. So the Church of Scientology was giving 501c3 status based on its promises that the illegal activities in violation of public policy ceased in 1986. And they agreed to never, ever be involved in that type of behavior again. Again, the pinky promise. The citizens of the world know this is a lie. Ex-Scientologists know that this is a lie. However, on paper and on record, Scientology has kept their promise. They have. All cases since 1993 agreement have been litigation of prior to 1986 allegations. They were either that or they settled before their closing. Cases were dropped for unknown reasons, probably from fair gaming. This pattern is with both civil and criminal cases. So on the record, Scientology is clean as a whistle. Remember, Willisheim was won in the civil case, but all the claims were for prior to 1986. In fact, I think they were prior to 1980. So Masterson, Haney, Baxter, and Gwain, the Jane Doe are all civil cases going on right now, but they're still ongoing. There's nothing on record. So here's some key takeaways from all of this that we're talking about. Clearly, the 1984 findings and opinions of the commissioners were ignored. The 1989 Hernandez decision from the Supreme Court was unlawfully ignored. The IRS issued the 9373 ruling contrary to the law. Thousands of children, elderly, and family and friends have been abused because of the willful disregard of a Supreme Court law, and thousands of children and elderly have been victimized and tortured due to the negligence. So, having successful litigated cases against Scientology will do two things. If you have the organization's purposes and activities shown as illegal or violating public policy, not just the person, as I said, those are the wording caveats. The organization is, by the Supreme Court decision of Hernandez, performing illegal activities and violating public policy. You can't write off auditing, ethics, and courses per the Supreme Court, the revenue ruling 9373. And as I said, it's been deleted from the IRS website like it's never existed. The second way to show it is through the sexual abuse, assault, exploitation claims. New claims are being made through the coordinated process with Andrews and Thornton leading the way. These cases will provide justice for those seeking, but also establish the illegal activity in violation of public policy when they cover up the abuses and hide the abusers. Andrews and Thornton contact information. I have it here, but I'll also put it in the description. So 3, the coordination of claims through the FBI, the Department of Labor, and Homeland Security. Forced labor, sometimes also referred to as labor trafficking, encompasses the range of activities involved when a person uses force, fraud, or coercion to exploit the labor or services of another person. The term forced labor describes forced labor schemes in which traffickers compel children to work. Traffickers often target children because they are more vulnerable. Although some children may legally engage in certain forms of work, coercing, forcing children to work remains illegal. Some indicators of forced labor of a child include situations in which the child appears to be in the custody of a non-family member and the child's work financially fits someone outside the child's family, or the denial of food, rest, or schooling to the child who is working. Here are the 6 steps. Review the UNOI claim. I'll give links in the description. That's a direct parallel to the Church of Scientology. Were you a victim of the year 2000 of forced labor violations? Whether you're 18 or over, doesn't matter. Under or over, doesn't matter. Minors are more egregious. You are protected under the TVPA, which is the Trafficking Victims Protection Act. Walk in, file online, or call the national hotline to the FBI. Tell them you want to report a crime. Give them a copy of or read to them the article from the UNOI case. Tell them it's the same, but Scientology. Be prepared with some W's, who, what, where, when. Then an officer will either talk to you then, interview you then, or follow up with you. We were talking a little bit previously about Mark and Claire Headley's suit, which was under the TVPA. The ministerial exception, the Ninth Circuit avoids constitutional question, holding that ministers did not state a claim that Church of Scientology violated Trafficking Victims Protection Act. So a little bit about that. Under the state claims, the state statute of limitations was incorrect, was not met. So it was thrown, the state part of it was thrown out for that. But they did bring in a broad exemption for the ministerial exception and the entanglement between the First Amendment and church doctrine. So the Establishment Clause concerns were minimal, and they should have kept up with it, but they didn't. And so this ended up being dismissed, but they could have kept on. One of the opinions was in the Headley addressing the district court's overbroad entanglement analysis could have avoided setting TVPA precedent on the basis of curtailed analysis and would have established the Ninth Circuit's own test as a mechanism by which it could limit the exception scope. So what they're saying basically is that the exception could have been limited to where the Headleys ended up pursuing and winning this case. But it was dismissed on its merit, and unfortunately, the Headleys did not succeed in this case. That, however, wouldn't necessarily be the case in this new Department of Labor case because so many of them were children, and now we have precedents in the UNOI case. So the UNOI case is more recent, sets more precedent, and I do believe would have, let me get rid of this window. Present. Go back to this. So anyways, my challenge to you is I will go ahead and link all of the information, all the documents, the Jason Polychron's videos, all of his documents and supporting resources, and tell me where I'm wrong. Let's talk about this. That fifth way is where we need to head, besides that they shouldn't have had that 501c3 to begin with. That pinky promise was made on broken pinkies, to be real honest. So what are your thoughts? Let me know. Everything down into the description box. Thanks and have a wonderful day.